AAA versus BBB, GR number 212448, January 11, 2018. This is for criminal procedure, specifically jurisdiction over the territory or venue. In criminal cases, venue is jurisdictional since it is conferred by the penal statute. The offense should have been committed or any of its essential ingredients should have taken place within the territorial jurisdiction of the court. It is determined by the allegations in the complaint or information. Note that a court cannot take jurisdiction if allegedly the offense is committed outside of that limited territory, or if the evidence adduced during the trial shows that the offense was committed somewhere else. The court should dismiss the action for want of jurisdiction. Facts of the case. This case was about the applicability of Republic Act number 9262, where the alleged marital infidelity was committed abroad, specifically in Singapore. AAA, the offended wife, filed a case before the Regional Trial Court of Pasig, where she resided. Said case was filed against BBB, the respondent husband, for allegedly causing AAA mental and emotional anguish in violation of acts of violence against women and their children under Section 5 of RA number 9262. Among other allegations, the offended wife claimed that the respondent husband, who was working and who have acquired permanent residency in Singapore, was allegedly having an affair and cohabiting with a Singaporean woman. It was also alleged that the last straw was when the parties had a violent altercation at a hotel room in Singapore during the offended wife's visit. Thus, an information was filed against the respondent husband, where the Regional Trial Court of Pasig found probable cause. However, the respondent husband filed, among others, a motion to quash the information against him. The prosecution opposed the said motion and argued that since the offended wife had been suffering from mental and emotional anguish wherever she goes, jurisdiction over the offense attaches to the Regional Trial Court of Pasig, notwithstanding that the acts resulting in said suffering had happened outside of the Philippines. Nevertheless, the Regional Trial Court of Pasig ruled in favor of the respondent husband and granted the motion to quash the information on the ground of lack of jurisdiction and thereby dismissed the case. The Regional Trial Court held that the act itself, which had caused a woman to suffer mental or emotional anguish, must have occurred within the territorial limits of the court for it to enjoy jurisdiction over the offense. To rule otherwise would violate or render nugatory one of the basic characteristics of our criminal laws, territoriality. In this case, such act was the alleged maintenance of an illicit relationship of the respondent husband with a Singaporean woman, which has been conceded to have been committed in Singapore. Therefore, the offended wife filed a writ of certiorari under Rule 45 of the Rules of Court to nullify the resolution of Regional Trial Court of Pasig, which granted the motion to quash the information. Issue: whether a complaint for psychological abuse under Republic Act number 9262 may be filed within the Philippines even if the illicit relationship was conducted abroad. Ruling: the Supreme Court held yes. A complaint for psychological abuse under Republic Act number 9262 may be filed within the Philippines even if the illicit relationship was conducted abroad. What Republic Act number 9262 criminalizes is not the marital infidelity per se, but the psychological violence causing mental or emotional suffering on the wife. Otherwise stated, it is the violence inflicted under the said circumstances that the law seeks to outlaw. Marital infidelity, as cited in the law, is only one of the various acts by which psychological violence may be committed. In Section 7 of Republic Act number 9262, venue undoubtedly pertains to jurisdiction. As correctly pointed out by the offended wife, Section 7 provides that the case may be filed where the crime or any of its elements was committed at the option of the complainant. While the psychological violence, as the means employed by the perpetrator, is certainly an indispensable element of the offense, equally essential also is the element of mental or emotional anguish which is personal to the complainant. What may be gleaned from Section 7 of Republic Act number 9262 is that the law contemplates that acts of violence against women and their children may manifest as transitory or continuing crimes, meaning that some acts, material and essential thereto, and requisite in their consummation, occur in one municipality or territory, while some occur in another. It is necessary for Philippine courts to have jurisdiction when the abusive conduct or act of violence under Section 5 of Republic Act number 9262 in relation to Section 3, Paragraph C was committed outside Philippine territory, that the victim be a resident of the place where the complaint is filed in view of the anguish suffered being a material element of the offense. In this case, the offended wife and children of respondent husband were residents of Pasig City since March of 2010. Hence, the Regional Trial Court of Pasig City may exercise jurisdiction over the case. The Supreme Court said that even if the alleged extramarital affair causing the offended wife mental and emotional anguish was committed abroad, the same does not place a prosecution under Republic Act number 9262 absolutely beyond the reach of Philippine courts. Therefore, a complaint for psychological abuse under Republic Act number 9262 may be filed within the Philippines even if the illicit relationship was conducted abroad. In applying the foregoing, the petition was granted, the resolutions issued by the Regional Trial Court of Pasig City were set aside, and the information filed by the offended wife was reinstated.